Namaskar all. Welcome all of you to the webinars which will give you basic knowledge about the court practice. What you learn in the college is different. I will not say it is not useful, it is very useful. In fact, it prepares you. The college education prepares you for the court practice with a formal degree. Now, when you come to the court, it is actually very different. If we apply for leave to the school or college, the application is totally different than what we write in the court. Now, here the real struggle starts of a lawyer, that how to write. Now, there are few books also available, but then it's a practical thing. Every court, if you travel across the country, every court has a different proceedings. There is a different way of writing the application. So sometimes it is actually very difficult. And to get into that mold, we need to practice. So practice makes a man perfect. Here also the same thing. There is nothing to worry. Today, I will start with the basic thing. Everybody is fascinated by the criminal practice. There is nothing wrong in it, because whenever you meet somebody, the first question, the police calls me, what should I do? That is the basic question which everybody asks. Now, in these cases, what happens that if you know the law, actually, you will understand that you will be able to answer the question posed to you. So today we'll discuss the basic thing. What are the powers of the police to arrest? Now, here I would like all of you to understand that up to 7 years punishment, the police cannot arrest the accused person or the person who are named in FIR. Now, it is actually a situation which is given in the your this CRPC, that is the old law, and new law is BNSS. Now, when you go to the CRPC old, is section 41. It says the police officer cannot arrest a person when the offense he charged is punishable up to 7 years. That is less than 7 years or up to 7 years. More than 7 years, it will be different story and different facts and different sections also. So up to 7 years, he or she will not be arrested. In this case, the police gives a notice, that is appearance notice, cause the people who are named in FIR to say their side story, record their statement, and let them go by giving sometime a table jamin, and sometimes they do say that go for anticipatory bail. Now, the under the new law, the section is 35 BNSS. Now, here also it is the same story, that only there are few things which are changed. One thing is actually here on the WhatsApp, a notice cannot be served. It has to be served physically. Recently, a judgment came from the Supreme Court. So the police has to, normally the police calls up or they give a notice by way of WhatsApp, which happens usually and nobody complains. So it goes on. But there are cases which went up to the court, traveled to the court and said, see, when I use the word travel to the court, it is the way the English has to be used when you are in the court. Now, what happens when the matter travels to the court? The court will ask whether the mandatory requirements are fulfilled under section 35 of the BNSS Act, that is a new act, and the old act, that is the CRPC 41 section. Now, these are two sections you must read. Now, there will be a question from you, where you will be saying to me that whether we should go through old law or new law. I would say both laws. This is generation which mine and yours will has to go, because there are pending cases which are 30 years old, and next 30 years or 20 years these cases will go on, and those cases which are registered before the new law came, they will be governed by the old laws. So you have to remember the old laws as well as new laws. Now it is actually difficult, but I'll take another session. What is the difference between new and old law and how you can go through it? Now what happens now next stage in this? If police still arrest you and the punishment is up to 7 years. You can go under writ jurisdiction to the Honorable High Court of the respective state and complaint against the police officer and also the police machinery. Also, the police officer can face the departmental inquiry for the arrest made, which is where the punishment is up to 7 years. See, when I'm saying repeatedly, I'm saying 7 years. Also, there is a possible the contempt of proceedings can be. Now, contempt proceedings are only before two courts, that is high respective high courts, and also before the Honorable Supreme Court. So it will go, the contempt proceedings, always remember, they do not will be before the subordinate court. It will be either the High Court or the Supreme Court, contempt proceeding. Never, I have seen few lawyers filing contempt proceeding, contempt notices before the trial courts or the subordinate court, which is not right practice. You should know that where the whenever there is a contempt proceeding, it will be before the High Court and the Supreme Court, High Court of the respective court. So BNSS section 35 and 41 CRPC Criminal Procedure Code. These two sections are most important part for starting a criminal practice for any lawyer, any law student, and for me as well. There are many judgments. One judgment I will ask you to read tonight itself before you go to bed, before you retire to bed. That is Arnesh Kumar versus State of Bihar. This is a landmark judgment. I'm saying this again and again. This judgment had put a foundation from where the police has stopped arresting people as per the guidelines of the Supreme Court, that they will not be arrested when the punishment is 7 years. There are some exceptions to this. This exception also we can discuss, like POCSO Act is there, or there are there is somebody who is repeatedly committing the crime. What the police will do? Police has to then record the reasons for arresting them. So this is very important. Arnesh Kumar versus State of Bihar, very famous judgment. You just Google it, you will get it. It is very important judgment. Everybody, not only the lawyers, every litigant and every person who is the citizen of our country should know this judgment. And it's just 7 to 8 pages. Kindly read it. It will be, actually, you will be able to help so many people across the country. Now, I will be asking Vishakha More to read a judgment. Now, why this exercise of reading judgment? You can read at home also. Why? See, whatever I'm speaking today or whatever I am, little bit knowledge I have, only because of the reading judgments. I'm requesting all of you, this is a habit I want to develop. Somebody developed this habit in me. And I want you also to continue that habit, which will make you a better lawyer. How? Let's see. विशाखा विशाखा को अनम्यूट कर दीजिए आप. This is just Vishakha.
Yes, ma'am.
Yeah. Can you start reading? Just a minute.
Okay.
Yes. Read it slowly. आराम से.
Judgment by Justice Madan Lokur. Having carefully read the erudite judgment prepared by Brother Chandrachud, I regret my inability to agree that laying an ordinance promulgated by the government of a state before the state legislature is mandatory under Article 213, subsection 2 of the Constitution, and the failure to lay an ordinance before the state legislature results in ordinance not having the force and effect as a law enacted and would be of no consequence whatsoever. In my opinion, it is not mandatory under Article 213, subsection 2 of the Constitution to lay an ordinance before the Legislative Assembly of the state legislature, nor would the failure to do so in the ordinance not having the force and effect as an enacted law or being of no consequence whatsoever. Further, in my opinion, an ordinance cannot create an enduring or irreversible right in a citizen. Consequently, and with respect, the contrary view expressed by this court in state of Odisha versus Bhupendra Kumar Bose and T. Venkata Shetty versus State of Andhra Pradesh requires to be overruled. In overruling these decisions, I agree with Brother Chandrachud, though my reasons are different. As far as the repromulgation of an ordinance is concerned, I am of opinion that the repromulgation of an ordinance by the governor of a state is not per se a fault on the constitution. There could be exigencies requiring the promulgation of an ordinance. However, the promulgation of an ordinance ought not to be a mechanical exercise, and the responsibility rests on the governor to be satisfied that circumstances exist which render it necessary for him to take immediate action for repromulgation or promulgating an ordinance. Finally, I am of the view that in the absence of any challenge by the employees to the first three ordinances promulgated by the government of the state of Bihar, their validity must be assumed. Consequently, even though these three ordinances may have replaced the employees, would be entitled to the benefits under them until they cease to operate, and the benefits obtained by the employees under these three ordinances are justified. However, these three ordinances do not confer any enduring or irreversible right or benefits on the employees. The repromulgation of the fourth and subsequent ordinance has not been adequately justified by the state of Bihar in spite of a specific challenge by the employees, and therefore they were rightly struck down by the High Court. Therefore, I partly agreed with Brother Chandrachud on this issue of the validity of the ordinance. The facts relating to these appeals have been detailed by Brother Chandrachud, and it is not necessary to repeat them. All that need to be is that in terms of Article 154 of the Constitution, the executive power of the state shall be vested in the governor of the state and shall be exercised by him either directly or through officers subordinate to him in accordance with the Constitution. In terms of Article 168 of the Constitution, every state shall have a legislature which consists of the governor of the state, and in the case of some states, two houses, and in the other states, one house. Where there are two houses of the legislature, one shall be called as legislative council, and other shall be known as the legislative assembly. We are concerned with the state of Bihar, which has two houses of legislature. Article 213 of the Constitution provides that when the governor of the state is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances as the circumstances appear to him to require. However, this is subject to the exception that the governor cannot promulgate an ordinance when both houses of the legislature are in session. An ordinance is promulgated by the governor of a state on the aid of his council of ministers and is in exercise of legislative power. An ordinance has the same force and effect as an act of the legislature of the state ascended by the governor in terms of Article 213, subsection 2 of the Constitution. Clause A of Article 213, subsection 2 of the Constitution provides that each such ordinance shall be laid before the legislative assembly of the state, or where there is a legislative council in the state, before both the houses, and shall cease to operate an exception of 6 weeks from the assembly of the legislature, or it before the expiration of that period of resolution disapproving it is passed by the legislative assembly and agreed to by the legislative council, if any, upon the passing of the resolution, or as the case may be, on the resolution being agreed to by the council. Clause B of Article 213 of subsection 2 of the Constitution provides that an ordinance may be withdrawn at any time by the governor. There is an explanation to the Article 213 subsection 2 of the Constitution, but we are not concerned with it. There is no dispute in the appeals that the governor of Bihar promulgated as many as 8 ordinances, one after the other, on the same subject. In exercise of his legislative power under Article 213, subsection 1 of the Constitution, none of these ordinances was laid before the Legislative Assembly or the Legislative Council. It is important to stress right It is important to stress right at the threshold that the promulgation of the ordinance is a legislative exercise, and an ordinance is promulgated by the governor of a state only on the aid and advice of the executive. Nevertheless, the governor must be satisfied that circumstances exist which render it necessary for him to take immediate action. The state legislature has no role in promulgation and ordinance or actions taken under an ordinance. This is within the domain of the executive. The state legislature kept a, the state legislature keeps and check on the exercise of power by the executive, though the governor through the governor. This is by a resolution disapproving an ordinance. The state legislature is expected to ensure that the separation of powers between the executive and the legislature is maintained, and is also expected to ensure the executive does not transgress the constitutional boundary and encroach on the powers of the legislature while requiring the governor to promulgate an ordinance. Article 203 of the Constitution does not require the legislature to approve an ordinance. Article 213 of subsection 2 of the Constitution refers only to a resolution disapproving an ordinance. If an ordinance is disapproved by a resolution of the state legislature, it ceases to operate as provided in the Article 213, subsection 2 and clause A of the Constitution. If an ordinance is not disapproved, it does not lead to any conclusion that it has been approved. It only means that the ordinance has not been disapproved by the state legislature, nothing more and nothing less. The concept of disapproval of an ordinance by a resolution, as mentioned in Article 213, clause subsection 2, clause A of the Constitution, may be contrasted with Article 352, subsection 4 of the Constitution, where a positive act of approval of a proclamation issue under Article 352, subsection 1 of the Constitution is necessary. Similarly, a positive act of approval of a proclamation issued under Article 356, subsection 1 of the Constitution is necessary under Article 356, subsection 3 of the Constitution. Attention may also be drawn to a proclamation issued under Article 360 of the Constitution, which requires approval under Article 360, subsection 2 of the Constitution. There's a conscious distinction made in the Constitution between disapproval of an ordinance, for example, and approval of a proclamation. And this distinction cannot be glossed over. It is for this reason that I am of the view that only disapproval of an ordinance is postulated by Article 213, subsection 2, clause A of the Constitution, and approval of an ordinance is not postulated by Article 213, subsection 2, clause A of the Constitution. The expression of disapproval of an ordinance could be at the instance of any one member of the Legislative Assembly in view of Rule 140 of the Rules of Procedure and Conduct of Business in the Bihar Vidhan Sabha. If the state legislature disapproves an ordinance by a resolution, it ceases to operate. One of the important issues before us is whether, after an ordinance ceases to operate, do concluded actions and transactions under the ordinance survive. After the promulgation of an ordinance, it is in this background, after the promulgation of an ordinance by the governor of a state at the instance of the executive, that the Constitution visualizes three possible scenarios. Firstly, despite the seemingly mandatory language of Article 213.
Vishakha, you could stop. Thank you so much. You read so well, Vishakha, and you inspired so many of others. Today, this judgment, I know, is little difficult to understand because it is totally on a subject which is actually very new, and normally this subject comes up before the High Court and Supreme Court. because if there is an ordinance, it is about the formulating the law of the country. So actually it will be little difficult, but with practice you will know. Those who are regularly reading the newspaper, they will know. Now, why we read the judgment? See, the judgment prepares you for the court craft. Now, what is court craft? It's again a very detailed subject, and every lawyer develops his or her own craft. That is called court craft. Every lawyer has that. It may be how to answer and how to speak before the court, how to get orders also. Now, when we read judgments, we get to the legal vocabulary. Now, this legal vocabulary is very important because what we speak before the court will actually make out the case for our client. How we see why the litigants or the clients engage the lawyer? Because we, as a lawyer, speak the legal language, proper language, and what is actually required before the court. So you cannot go just to the court and say, I want this bail. No, no, no. You have to make out a ground why you are entitled for bail or for any relief from the court. Now here comes the role of the legal vocabulary. Now I'll be sharing something very, very interesting. This video I will also share in the later on the YouTube. Uh, is it visible? You can show the hands. The first word is erudite. The meaning is having or showing great knowledge. Now see, my team has prepared this, Vishakha and the Sanghapriya. The question posed by the erudite counsel for the complainant lies within the decision of the Supreme Court. See, erudite, the word is very important. Whenever you are there in the court, if you say it is a erudite explanation, here erudite counsel, there is somebody who is having knowledge. This word required to be used. When you keep on reading some judgments, you will find out this word. Now, the next word is exigency. Urgent need or pressing requirement caused by a specific situation. It will be difficult at the beginning to understand, but if you go on reading the judgments, you'll find these words regularly. Under section 125, see, exigency means urgent need. What is the exigency? The opposite lawyer may say, but you will say the exigency is the reason. The child custody is needed for what is the reason for a mother. Here we have taken out one sentence under section 125(4). See, again, this is the knowledge. Section 125(4) of CRP, that is the old law, provides for such exigency. That is the urgency, where husband can raise his defense regarding adultery of wife to avoid payment of maintenance amount. If you can take away this sentence, you will be able to do some justice for your client whose wife is living in adultery, still he has to pay maintenance. Now there is another word, threshold. At the beginning, threshold is the common word when you go to the High Court and the judges will be using. The petition dismissed at threshold as it did not comply with the mandatory provisions. Beginning में वो petition को dismiss कर दिया गया. Manifest. Now the word is to make clear or evident. Manifest. Normally we say there is a manifest error in the petition, Lordship. Review is not maintainable unless the material error. Material means very important. Manifest on the face of the order. This word you will be required to use. Today these words may look very heavy for you, but as you go on practicing, it will be actually very easy. Now this is the fifth word is nexus. Everybody knows this nexus. A complicated series of connection between different people or things. This is also used in civil. We always say it is used in criminal. No, no, no. It is also used in the civil matters also. There was direct nexus between the injuries sustained by the injured person and the rash and negligent act of the accused. There is a connection. So see, nexus is a very heavy word used in mostly in criminal practice. But I have, when we were doing research with my team, I saw that it is also used in the civil matters also, and very beautifully it is used. So it is how you go on adding words to your vocabulary. Eventuality, a possible event or outcome. Eventually, what will happen? Normally, we speak. Eventually, the appeal preferred by the appellant was allowed. Eventually, an order of cancellation was passed. See, It's not ultimately. You can use this word eventually. Now, next is very important word, analogy. Mostly you'll find in the old judgments a comparison between two things that show the way in which they are similar. Analogy. The analogy is similar. I do not think that this court should apply the analogy of the article in the Limitation Act. Now, it will be difficult to explain this, but when you go through the facts, you will come across that analogy word is mostly used to show that how they are, two things are traveling differently, but they are similar. Evade. Now, very easy word to avoid. The defendant evaded the partition on one pretext or the other. Or you can say he is avoiding the service or he is evading the summons. Contemplate. Consider. Now, the word contemplate is also used by the judges in the before the court also when you're there, and also in the judgments. This article obviously contemplates, let's consider, a suit for possession of property where the defendant might be in adverse possession. Next is inception. This is a very common word. Normally, since inception he is doing this. Commence, or since beginning, since started. There was no intention on the part of the petitioners since inception to cheat. Beginning say to cheat or commit. Suppose somebody gave a check which is got dishonored. Then while arguing, you can say since inception there was no intention to cheat or commit criminal breach of trust against the respondent. So these are 10 words, but let me tell you, if you add 10 words every day, it becomes 300 words in a month, and then 3,600 words, 12 threes are, then so many words. If you know these many words, your legal vocabulary is totally different before the court, and you'll be able to impress the judge and the client equally. Now, the most important and the last part of today's series is about how to get work or how do juniors start their career. If you're a first generation lawyer, or let me tell you, even second generation lawyer, they also have to start from the scratch. It is not about nepotism. It is something like that, like in film industry. It is how you start your practice. How you, when you get your case, I will say one thing only. Mouth publicity works in all field, whether it's legal or it is something else. It is whether you're selling the cloth, whether you're selling the utensils, or whether you're selling the fruit or vegetables. Mouth publicity is the most important part of any profession, any business. Here also it is the same thing, but there are some basics which I feel I should be telling the all of you that how it is easiest part. The first thing I will always ask all of you to visit court. Today I can see there are many people who have joined from the breadth and length of the country. Some are from Nagaland, some are from Tripura, and I have seen from Tamil Nadu. There are many places. Now we all are lawyers. Today we are connected. It's 200 plus. I have not seen the numbers. It's 255 now. So if you know each other, it's a one network. Today I'm sitting at Mumbai, and I may be visiting Delhi whenever my work demands at the Supreme Court. Whenever I get a case there, I go there. But I'm basically from Mumbai, so I practice here. Now somebody here is from Kalyan, that is in Maharashtra. Somebody is from Tamil Nadu. I may be able to refer a matter to you. But when I'll know you, this is a lawyers network. There's nothing wrong with it. We are not allowed to advertise. But knowing each other is not a condition put to in any profession, less the our profession. So you must know each other. You should make. You should be in the court. The first thing I will ask you, every 30-50 kilometers, there is a court in India. आप कहीं पर भी चले जाओ, हर जगह आपको कोर्ट मिलेगा. Just sit for 2 hours. I have met few people who told we cannot go to the court. We are housewife. We have done LLB long back. I'm telling them, when your child goes to school, please go for 2 hours. Only for 2 hours to the court. Just go and sit. Lawyers will know you. They will tell you, please do my work. I am away. I'm going to another court. So you must visit to the court premises. At least for 2 hours. or at least for 1 hour. When I go to the court, I have seen that many senior lawyers, they sit even if their cases are over. I think we should learn something from them, right? Then secondly, I will say internship. Now, how you are doing online internship? I started this practice in the corona to have online internship. Now, internship is not something that you just sit at home and learn. But this is what I can do best with you. Now, what I'm telling you, that internship, you get hold of any lawyer, request them, don't ask for money. Ask them, just ask me to allow to hold your files. अब उनका फाइल उठा लो, उनको बोलो सर हमको बस आपके साथ रहने दीजिए. If this much also you can do it, trust me, it will be nice of that lawyer, he or she, to help you. मुझे तो वो लगता है कि फाइल उठाने को भी दे दे तो उसमें से 4 लाइन में पढ़ लो, तो कहीं हम मेरे दिमाग में कुछ चीजें चली जाए. दैट वन थिंग आई वांट टू टेल यू. तो इंटर्नशिप कीजिए, go to any lawyer, request them that I want to do internship. They 10 will refuse you, but the 11th one will say, yes, yes, come from tomorrow. This is my timing. Whatever suits you, go. Don't say part-time karna hai, full-time karna hai. Just go and attend. Don't ask for money. Just ask them their blessing and legal knowledge share करवा दीजिए, बस इतना बोलिए. Next, I will say कि travel. There are total 41 high courts in the country along with principal benches, and there are benches like in Maharashtra, Bombay, we have Goa bench, Bombay principal bench, Kolhapur and Nagpur, like 4. So there are total 41. I have traveled almost 35 high courts of the country to present my book. Vandana, if you can share the book in the chat box. It is on drafting. If you can go through it, all the high courts again, Maharashtra, almost all the court library. If you can go through that book, one. Secondly, if you travel, then you know the lawyers. I have learned when I go to Nagaland, I have sat in the court. I have gone to Madurai court. I have sat in the court. You learn. I remember once I had gone to Vishakha Patnam also. I was just trying to learn, though I didn't know the language. Kerala also I have gone. कहीं का भी केस मिले उठा लीजिए, ले लीजिए. बिगिनिंग में यू हैव नो चॉइस. प्लीज टेक योर केसेस and don't go for money, but go for actually work. Then money will follow. Also, secondly, you should be well connected. I wrote a message today at WhatsApp to you, and you are replying after 3 days. Not done. Please, please, please. No, you should be connected by 24/7 with all the people. Lawyer को कोई छुट्टी नहीं होती है. It's 24/7 हुआ. See, today it is almost now 10:30, around 10 past. But still, we all are talking about our profession because there is a commitment, there is determination to do better. So you need to join some lawyers, do internship, visit courts, travel across the country to the court. Across the country, at least district courts near about you. In 50, 100 kilometers, you will find 5 courts. And there will be different experience of the judges, different experience of the lawyers, and also you will know each other. That will be a bigger network of the lawyers. And there are, like how I am taking internship, there are so many online courses that is free of charge. How I am doing it, so many, in Corona time, there were so many, I would say, webinars which are there on the YouTube. Please go through that, make it a point, try to read one judgment every day. So this is the way you should keep on. So you should travel, breadth and length of the country nahi hua, so at least your city, your taluka, your district, that is also more than enough. So the key, or I would say the main factor in developing your practice is the connection of the people. As people knows you, they will definitely refer you matter. But if they don't show you in court, you don't pick up the call, you don't answer their messages, the client will in 5 minutes with cell phone, they will find another lawyer. So what will happen? Your work and your chance has gone. I'm not saying that there should not be life and work balance, but this is the age you should give some time. At least Monday to Saturday, you should give some time. This will actually help you to develop your practice. And when you do one case properly, the same client will refer you to another 10 clients. I have, in my career, have seen opponents referring me again. So it was not enmity. I have never shown any enmity when I was in the court. I had fought my client, but decently. The decency also you will learn over the years when you visit the courts and you will see the senior lawyers arguing. So visit the court is the best thing I can tell you. And there only, that is your karma bhumi. आपका कर्म भूमि आपका कोर्ट है. प्लेस ऑफ वर्क नहीं, प्लेस ऑफ वर्शिप है. मंदिर के बाद, मस्जिद के बाद वही जगह है जहां आपको जाना है. मैं तो कहती हूँ हमारा मंदिर मस्जिद सारा ही कोर्ट का प्लेस ही है. 2 hours, 20 minutes, whatever time you can spend, do spend whenever you find time. You can go in second session 3 to 5. You can go in first session 10 to 1. I have a video on the YouTube which says जज की गाड़ी आने से पहले कोर्ट जाना, जज की गाड़ी निकलने के बाद कोर्ट से निकलना है. I'll share that tonight if possible. So that is the key to your success. So that's all for today. I'm very thankful to all of you to be a great audience to me. I'm so thankful. God bless you all. If anybody has question.
Thank you so much, ma'am, for dedicating this time for us.
Thank you. Thank you. Welcome, dear.
Thank you so much, ma'am.
Okay. And I would request all of you that you all can do one thing. You can share the links with other people also. It's not a question of certificate, I will tell you. It's a question of learning. सर्टिफिकेट वो दीवार पे तंगा रह जाएगा. व्हाट इज इम्पोर्टेंट, इधर हमारे पास कुछ है और वो फिर यहाँ से निकलेगा, यहाँ से निकलेगा. दैट इज वेरी वेरी इंपॉर्टेंट टू ऑल ऑफ यू. थैंक यू सो मच. आई एंड द मीटिंग टुडे. थैंक यू. थैंक यू एवरीबॉडी.
madam.
Thank you. Thank you.
Thank you, ma'am.
Thank you so much, ma'am.
Thank you so much, ma'am.
Thank you. Thank you. You can
Thank
write in the
you.
group. Group is
Thank you
open
so
to you.
much,
Write you. You can write in group. Thank you. Thank you.
Thank you, madam.